Now, Millets, the next point I wish to come to, Millets, is to remind your lordships about the statement made by the governor just now, a little earlier, saying that, look, I don't wish to file any reply. Your lordship remembers that we had said that the governor has specific names and dates with investigation, after investigation of Millets complaints pending. And if your lordship will turn to Millets, well, I don't have to give your lordship the note, just note the details, Millets. Annexures from 693 to 696 and 701 to 702. These are much prior complaints, in some of which investigation is complete, charge sheet is filed. The names are Malus Sashikala Joli, Murgesh Nirani, H.D. Kumaraswamy,
Charge sheet is
Nathan
filed.
Reddy.
Charge sheet is filed.
Investigation is complete in any
Complete.
case.
Charge sheet is not yet filed.
In one Malus, I'm told. In one
Because without sanction, charge sheet cannot be filed.
take out details. What is it? Yeah, well, it's investigation complete, therefore a charge sheet is filed subject to the sanction. That is the correct
Charge sheet
way.
is also filed.
Yes, yes. Yes, yes.
All right.
Today, Malus, when I say that anybody comes to you and you immediately grant, well, the person who granted has at least these 4 names I have given. And the pages are Malus 693 to 695, then 696 and 701. This is an article 14 points straight away, staring you in the face. Now, Malus, there is no reply and none. And in fact, last time orally it was said, orally, that we will let you know about this. Specifically said.
No,
Now-
he has now also said that he will produce the records completely.
So, Malus, that is, no, but the fact of the, correct, no problem. Records are between the court and there, no problem. But the fact of the matter is that these 4 are actual real human beings, actual real complaints and applications, actual real pendency, much earlier dates, investigations complete. That's all that I'm saying. I don't think the record, whatever is produced, can be different. Now, Millets, the next aspect is another simplest, straightforward point without meaning to over-amplify or oversimplify. The sanction must go. I'll tell you why. Your lordship has now held absolutely crystal clear that sanction is fully reviewable. That is beyond doubt. The law has got well ahead of that. It's completely and totally judicially reviewable. The 2 judgments amongst many Amalus, Mansukha 1997 and Yedurappa 2015. My compilation has them. I'll just take your lordships to them. So it is completely reviewable like judicial review of Malus administrative public law action. Be it Malus for ulterior motives, lack of application of mind, Wednesbury unreasonable, etc., etc. My lord knows that well. There is, apart from that, Malus, I have given detailed additional law also, and I will Malus cite some of that. Well-established principle. Rameshwar Prasad, State of Gujarat, R.A. Mehta, and of course, very homely flavor of Karnataka, S.R. Bommai. Directly, Malus, they say, it's fully reviewable. I've got the paras also. 9 judges down to division benches. Now, Malus, the beauty of this case is that the governor has not applied his mind or dealt with a single point on the merits of the sanction. I repeat, that's why it's a simpler case. Not applied his mind or dealt with. Whereas you can even deal with the subject, which shows that you've dealt with it without applying mind. It is possible. But for not applying mind, for me to show non-application of mind, I must show that you've dealt with it. The governor has not dealt with a single point. One point he deals with. I am not bound by the cabinet advice. So let me for a minute accept the honorable governor and proceed from there. I'm not accepting this, but I'm just saying, please proceed for a minute. You are not bound by the cabinet advice. Let us take it as it is. Therefore, you are acting on a tabula rasa. The tabula rasa is that this man has applied, this application has come.
No, this requires an independent decision. Sanction against this, the chief minister or other
Therefore,
functionaries.
I'm for a minute
It is an
accepting.
independent decision of the governor. He cannot fall back upon or need not fall back upon the advice of the ministers.
I am just proceeding on that basis.
Yes.
There are some nuances in Navam Rebia.
Ah,
It is, but I'm not arguing that. I want to make it simple first. For a minute, please assume against me and in favor of the governor, as my lord felicitously put it, independently decides. He's the cabinet, not bound by the cabinet.
yes.
He's the complainant. He or she comes to me. I'm the governor.
In this particular issue,
Yes.
not in every issue. He is definitely bound by the
No,
bound
no,
or
we
to
are
follow
talking of
aid and,
sanction. We are talking of
aid and
sanction.
advice definitely is there.
No, no.
But
on
in-
the sanction
On the
regarding a
sanction,
chief minister.
yes.
So well, we need not trouble ourselves for a minute. For this purpose, at the moment, I am assuming against myself. So, Malus, what happens? I am the governor. He or she complains. As a lordship used the word independently, I have to give. Now turn to page 41. There's nothing.
No, that will,
There's nothing.
that you have told. Yes.
What do I show your lordships? There is nothing. There is only one point. I received a complaint. I received an advice. I am not bound. Hence, I grant sanction. I don't want to exaggerate, but I repeat. Is that not sufficient to quash the sanction? My lord used a milder word just now, independent.
No,
It has to be
independent
an
decision making.
objective consideration with reasons, with application of mind reflected in the order. There must be something. It can't be that because I'm not bound by you, therefore I must grant sanction. That's what the order says. Therefore, Maharaj, this on the merits is the most strong ground on the merits of the sanction I'm now. And it is sufficient to set it aside. Now let's
Yes.
just pick up that bunch, only the index. I'm not going to read it. To
The
let's give the index. Of the
judgments?
judicial- Yes, sir. Just to tick it, just so Lordship knows where is what. Is it all here? Where is sanction is reviewable? Sanction is reviewable. Where? Which one? The index where? Well, it's
Here.
there are some of them which are separate, so I have to little scattered. May I make my lords just stick it? In this large bunch, one is scattered at serial number 2 at
Acha,
big, I'm sorry, you should not have put
ಹೇಳಕ್ police
new
ಅವ್ರಿಗೆ.
serial numbers every time. Why do you make an index like this? Not the index. We have put Malos fresh numbers each time, so it creates some confusion. If your lordship sees Malos page 2,
Page 2, sir.
of the index.
Yes.
So one is Malos Mansukh Vithaldas Chauhan.
Next is.
Yes.
And the paras of this Malos are. The paras don't make me wait. You are a
Para
complete
14,
mess.
17, 18 and 19.
Para 14 to 18. In fact, 14 to 19.
Yes, sir.
Take out. These are
Of Mansukh Lal Vittal Das.
That your lordship has ticked below the number 2. I'm sorry, my index should have had continuous numbers, but we don't have.
No, that's
it's
all
number
right.
2.
No problem.
Yes.
Yes.
Then Malos
20.
Yedurappa
22
is
to
on the next page, number 5.
22 to 30. 22 to
Yes.
Here, Malos, para 22 to 30. But I have also culled out the more specific paras like 27, 28, 30. Malos.
Yes.
I will also, Malos, give a lordship a digest of just the paras with the extracts to make it shorter later on.
That's better.
That. Will you make a note of that? Just not all, just the relevant ones, the underlining highlight. Just it's much easier. Now, Malos, in addition to that, point 11 below. The other judgments, Malos, which talk of judicial reviewability very clearly is the Constitution Bench of Ramesh. Where is the bunch?
Yes.
This is Malos, a volume 2. These are high-powered numbers in terms of benches. Malos. The numbers are larger. Constitution bench is 9 judges.
Yes, sir.
So one is Malos Rameshwar Prasad, which is the number 4 serial on the first page.
Yes.
Here your lordship may write on the margin, I'm sorry. Maybe I have to give it to lordship in writing, but it's 128 and 129. This is a constitution bench, 5 judges.
Yes.
And Malos 140 to 145,
Yes.
para numbers. The previous 2005 Rameshwar Prasad, para 7 will suffice.
Yes.
So 2 Rameshwar Prasads,
Yes, sir.
both are constitution benches. Well, the state of Gujarat. Where is state of Gujarat? Well, I'm very sorry. What we'll have to do is extra, because we've given them all over the place. So I'll give the
It's all
extra.
right, no problem. Yes.
There is well, a state of Gujarat, which is 2013, 3 SCC, page 1, para 68. I had the privilege of assisting the court here.
So all of these are concerning Article 356.
So, Malas,
What is that you want to rely on?
so I'm saying, Malas, governor's actions.
Huh.
The narrow ones I've given you first two are Mansukha and Yedurappa.
Yes.
But Malas, I'm saying governor's actions are fully reviewable even in the A for sure I category,
No,
totally and
I
completely.
have no doubt about
That's right.
it.
That's,
Yes.
so I'm just, Malas, this is 45. That's why I'm not reading it.
Yes.
I'm not even reading it, Malas.
Yes.
I'm giving a lordship decided, and it's capped. It's capped by Bommai in Malas the paras. So what I'll do is, with your lordship's permission, I will take Malas extracts and only some of them and underline them and give it to your lordships. I am not even reading them.
Yes.
It's too well established. Now, Malas, on the natural justice part,
Same compilation.
please note the 3 dates first. Yes. Whereas note 3 dates. A show cause is given to me on 26/7/24, which is at page 265.
Yes.
And Malas, what date of my reply? Date of my reply.
3.
And Malas, meanwhile, in the interstices of the government, the AG has given an opinion on 31st of July 24, as the documents now show, at page 267. And the cabinet note is at 1 August 24, which also attaches the AG's opinion at page 336. But what is missed out here is that I separately replied on 3rd of August 2024
Page 6.
at page 630. And I was also cited a lot of law and all the details, etc., etc. Now, all of this is decided by the order at page 41, dated 16th of August 2024, which, as your lordship has already noted,
Yes.
adds this gratuitous sentence that R4 and R5, which is para 2 of that document, page 41, para 2, which is when I first learned of it. But this is one part of natural justice. Natural, very many parts of it. This is A. Part B of natural justice is that all the points I have raised, forget the cabinet, you're bound or not bound, I'm not bothered. I have raised these points of diverse nature. You have not dealt with any. That's point number 2 of natural justice. It is, your lordship has the order 41 to 46. I can't add to it. I can't subtract to it. Nothing. Files also, which are uncommunicated, can't, as far as the final order is concerned, add reasons. You can't say that I wrote an order like this, that I had 28 reasons in my file back home. That is not an order. You can't justify, Now, in this light, your lordship put a question on the scope and nature of natural justice. So before I read those 2 judgments, take them out, keep the paras ready. I want to just give your lordship first principles, 3 or 4 points, then your lordship will. One is adverse civil consequences, Bina Pani Day. Second is the consequences here are much beyond adverse civil consequences, because it is not only the person who is the chief executive of the state. I have said in the opening that the larger constitutional issue is that if you are elected with a full-throated election where huge amounts of money are spent by the opposite side, but still you lose, somebody is elected. He may be bad governance, he may be a horrible governor. Only the people who elected have a right to remove him. If you can use this methodology to remove him or initiate removal, then it's a negation, which is why all safeguards have to be read. Obviously, if somebody is steeped in crime and you have material, yes, give reasons and start removing him. But every filtered safeguard must stand at the threshold, because you are negating the mandate of the people. If you accept this larger principle, and your lordship state, Karnataka, was the first to make basic federalism part of basic structure in Bommai. It's very interesting. We digress for a minute, Federalism, if your lordship Googles the constitution, is not a word found anywhere in the constitution. I gave a lecture once, I examined it, there's no word called federalism. The word federal comes up because it's a federal court we had.
No, because we
Supreme
are
Court.
quasi-federal.
No, that's all right. But even quasi-federal has some elements of federalism. Kenneth Weir called it quasi-federal. First Australian jurist to use it. But federalism, you only get reference in the text of the Constitution to federal court or federal. Federalism, without being mentioned in the Constitution, your Lordship said 9 judges Bomai held to be a part of the basic structure of the Constitution. So, this is another aspect of assaulting federalism or negating federalism if you can remove elected chief ministers. The third, which is why your Lordship must read in all safeguards. Third aspect is that famous phrase of Mr. Ambedkar. You cannot have two swords in one scabbard.
That you told me.
Elected, unelected. Therefore, keeping that in view, your Lordship will just see in natural justice, you are having a plethora of material which you in your independent sovereign decision making has a right to overrule, but with reasons, with material, with thinking mind. Nobody is grudging you a right to act, but we are grudging you a right to do it in a proper way. That is what natural justice is, not hearing only.
Decision making process.
That's a much better word for. Oh, I heard you. I sat like a sphinx, like a statue. I heard you. Now go home. I've written the order already in my desk. I take it out, give you the order. That is also natural justice. I heard you. It's not hearing. It's the decision-making process, that's exactly the correct word. Now, in the light of that, turn to, let's first turn to Rajesh Agarwal, paras, which is, 2023, 6 SCC, page 1. Kindly hand it over to me. You give me this, then you come to mark copies.
Because mark it, this is the things you given to judge.
Volume 2, Malaz.
Yes.
Now, let's just kindly note I chose this first, not because I appear in it, Malaz, but because the facts were purple. They said that these are defaulters for whom I was appearing, who have crores and thousands of crores, and they must be declared fraud. But they're very interesting. RBI circular says NPA is one part, but you must declare them fraud so we can take criminal action. Now, the process of declaration of fraud, they had already got notice about NPAs. Natural justice was satisfied. Bank said, why should we have another natural justice? We've already declared them NPA. These are fraud people. So they declared them fraud without natural justice. Now, the arguments for us, therefore, are very useful in that light.
It's para 36 onwards.
Yes, I'm grateful. And this went on for quite a while President Chief Justice was in court too, Malas.
Yes.
He was the senior most puny judge. Starts with 41, if your Lordship will turn for a minute, Malas. Audio alter starts with 36, my Lord rightly notes. But come to Malas page para 41, which is the Bina Pani Day. That's why I don't have to cite all of it.
Yes,
Lordship
yes.
gets it all there. So this is how the court, Malas, your Lordship applies natural justice in the larger decision is a subject neutral concept. It is subject neutral. It cuts across the entire law. Then was 42, Canara Bank. Administrative actions involving civil consequences. And see the italicized portion at para 45, italicized by the Supreme Court, not by the SCC. Even an administrative order which involves, so administrative order also. You are talking of much more serious orders here. This is not administrative order. Then let's come to 46, consistent pattern, not merely property or personal rights, civil liberties, material deprivation, non-pecuniary damages, every order, civil consequences. So, Bina Pani Day is the anchor which is now built upon very much widely by this judgment and other judgments, very much more widely. Now come to 67, that master circular of RBI starts at 48, etc. I'm skipping all that and bringing.
What is held it as para 81?
Well, that's true. I just want to take 2 minutes more on 67.
Sir.
67.
Exclusion of.
Now,
Right.
This is that principle, express exclusion, express inclusion. But you must read into it the interstices. And there, your Lordship will see Swadeshi. Just see, just see the third line of 67.
Yes.
This is what I was saying, It's taken from that Cooper v. Wandsworth.
Yes.
The common law will supply the omission of the statute is the principle, where it is silent on granting an opportunity of hearing to a party where rights and interests are likely to be affected. Then Swadeshi, then come to the next page. See the first few lines of para 44 quoted at page 37 of the SCC. In short, the general principle as distinguished from an absolute rule seems to be that where a statute does not in terms exclude this rule of prior hearing, but contemplates a post-judicial hearing amounting to full review, then such a statute would be construed as excluding the audio alteram proof at the pre-decisional stage. Conversely, the statute conferring the power is silent with regard to the giving of pre-decisional hearing to the person affected, and the administrative decision taken by authority involves civil consequences of grave nature, and no full review or appeal on merits is provided. All of it applies to me, Malas. All of it. Courts will be extremely reluctant to construe such a statute, excluding the duty of affording even a minimal hearing, shorn of all its formal trappings. Your Lordship is in Malas at the worst in virgin territory, where your Lordship must lean in my favor. Is my humble submission, reading the way it is written, Malas. Yes, if there's a exclusion, different matter. The court must make every effort to salvage this cardinal rule to the maximum extent possible. Then Malas Swadeshi goes on in 69 and leave that and come to Malas 70. Mangilal is important, Malas. 70.
Yes,
Even if a statute is silent and there are no positive words, kindly see this, Malas.
yes.
In the act or rules made thereunder, there could be nothing wrong in spelling out the need to hear the parties whose rights and interests are likely to be affected by the orders that will be passed, and making it a requirement to follow a fair procedure before taking a decision. More important is fair procedure, not only Malas the formality of the hearing, as my Lord rightly put it, decision-making process, and making a requirement, unless the statute provides otherwise. The principles of natural justice must be read into unoccupied interstices of the statute, unless there is a clear mandate to the contrary. No form of procedure should ever be permitted to exclude the presentation of a litigant's defense or stand. Then Malas 5 lines later, where the statute is silent about the observance of the principle of natural justice, statutory silence is taken to make compliance with the principle of natural justice, where substantial rights of the parties are considerably affected. The application of natural justice becomes presumptive unless found excluded by express words of statute or necessary intendment. Its aim is to secure justice or to prevent miscarriage of justice. Principle of natural justice do not supplant the law, but supplement it. Then Malas, look at the argument of RBI. Malas, I had the privilege of arguing for the Malas respondent, which succeeded. RBI and lender banks have contended that the principle should be excluded in cases where there is promptitude or exigent action. Then Malas, I'll skip that and come to Malas para 74. Swadeshi. They Malas distinguish and apply. They do both things, Malas. Then 78 is Kesari. Now, Malas, now this is on that investigation. Your Lordship doesn't need to actually give natural justice in that sense, is the commonly assumed belief. But they said, no, you must give all the material. Please see. In Keshav, this court was dealing with the issue of takeover of the company after completion. I mean, these are much minor cases compared to what is happening to this man here, the petitioner. Much more minor, I would say, in relative terms. Completion of a full investigation into the first. The issue was whether the report of an investigating body appointed by an administrative authority should be made available to the person concerned before the authority takes a decision. Your Lordships could brush aside a case diary. It's an investigating agency. Don't give it to it. What does it matter? No. The court said, no, you must give it. Well, just see page 41, where they say, unless the report is given, the party cannot make any effective representation about the action that the government takes to pursue. Malas, what I would have said in addition regarding R4 and 5 is up to me. You never gave it to me. Then Swadeshi again is cited. Then Malas, Tulsiram Patel is 80. I will skip that. And Malas then come to straight away 81 onwards, Malas, and then finally 89. You put here 89 and suddenly 85. 85, Malas, is fairness in action. Now, this is a larger principle of natural justice. Is it fair? What is this tearing hurry if you've got 12 other complaints or 6 other complaints pending? Why this tearing hurry? This is all your holistic approach. Well, the Lordship, the writ court looks at it holistically. Fairness in action requires that procedures which permit impairment of fundamental rights ought to be just and fair. The principles of natural justice have a universal application and constitute an important facet of procedural so-and-so. Violation of Article 14, etc. Now, the natural justice is not part of Article 14 in the early years. Now it is part of Article 14. The most powerful article in our Constitution, I would say even higher than 21 is 14, but at least on par with 21, 14 and 21 are the two Malas, most biggest Brahmastra which this Constitution has. Then Malas, para 89, your Lordship says that even a statutory provision should be read to lean in favor of natural justice on the other hand. That's 89. And then Malas, CB Gautam was Malas, is a very good example. Your Lordship knows 20C, now it's gone. Compulsory takeover of property.
Yes.
Why should you have to give notice for this? You are almost dealing in a quasi-penal context. You are saying something is wrong with your income tax returns, we are taking over, etc., undervaluation. Still, and this was completely not there in the Act 20C, which was introduced. See what the court says, para 90. Whether a show cause must be issued to an intending purchaser and seller of property before making a compulsory purchase. Chief Justice Kania said that where the validity of the provision would be open to serious challenge for want and opportunity to be heard, courts have read such requirement into the provision. And here you have a judicially reviewable. What is the point of a judicially reviewing something between the governor and your lordships? The man affected has no role in it. What is the judicial review your lordship will do? Only just whatever he has said, your lordship will sit on that. He has no malas. The learned judge will have no inputs from me to the governor. And then it goes on. And then ends in please. And then they ask you in 94.3 and 94 to say you must first follow the fairness, then pass a reasoned order. Now see that 93. It has been elucidated in the preceding paragraph that the classification of a borrower's account as fraud in accordance with the procedure laid down in the Master Directions on Fraud entails significant civil consequences for the borrower. Since the Master Directions on Fraud do not expressly provide an opportunity of being heard to the borrower before classifying an account, the rule of RD, alterum partem has to be read into the provisions, etc. Then, before concluding, we also want to address the argument by the borrowers that the requirement of passing a reasoned order must be read into. They relied on JAR developers where it was said that this must be made by a reasoned order. And then, they say, of course, you must give reasons. But of course, it's not like I'm asking you to write a judgment. You're not a judge, but you must give reasons broadly. That is okay. I mean, nobody's saying that you're a judge who has to give a reasoned judgment. To the same effect is the more general case, which has been cited now in all your lordship's cases, including this one, Dharampal Satyapal. That is 2015. In the compilation, it is the previous one, 2015, 8 SCC 519. Para 27. It's a frequently cited judgment.
Yes.
It brings to speed all the case law on this. Now, one of the other facets is, what does it matter even if you heard me, the result would be the same. Lordship has dealt with it long ago. Now, even if you hear me, the result would be the same. Why should I waste time hearing you? See, 42. Important question posed by Mr. Sarabji as to whether open to the authority which has to take a decision to dispense with the requirement of the principle of natural justice on the ground that affording the opportunity will make no difference. To put it otherwise, can the authority dispense with the requirement of issuing notice by itself, deciding that no prejudice will be caused to the person against whom the action is contemplated? Answer has to be in the negative. It is not permissible for the authority to jump over the compliance of natural justice on the ground that even if hearing had been provided would have served no useful purpose. Because Gandhiji's old dilemma, means and ends. He always insisted on the means. Ends are okay, but means, that's important. Then 43, they again affirm that principle of prejudice. One is that no difference would happen. Second is prejudice. Both are affirmed. We still need natural justice. And then it goes on, to deal from para 41 onwards to 44. And ultimately, they give primacy to natural justice. Now, my next point relates to a reminder for 2 minutes only of the very remarkable dates in this case, which your lordship noted with me last time. Lordship notes will bear it out. There are very few dates. May I just remind you, lordship, those 6-7 dates? Correctly typed? Well, I had oralized it, lordship, and
Yes.
I've got a 1-pager just to put it on this here. Give to other side also. Same question.
Yes.
Well, these are all in Kannada, but of course, we have Kannada experts here. Whereas 1992 is the notification. 98, it is denotified. And whereas right through, not a single file.
No.
So what?
What happened after denotification?
this will, what is coming up.
Ah.
Is coming up. I'm just saying one general thing, Mulus. Not a single file came to him in any capacity as chief minister, deputy chief minister, or the relevant minister.
That
He was
which,
not never holding that portfolio. Never. Survey is denotified through the government notification. Then Mulus 3 is 2004. Records show the change of land ownership from Devaraju. Mulus, first was Ninga. Ninga's son is Devaraju. And finally comes Mallikarjuna Swami. Now, Ninga and Devaraju, which is for 20, 30 years earlier, have no connection, no relation with the chief minister. None. In Malus 2004, the sale deed comes to my brother-in-law, whose name is Mallikarjuna Swami. That is 2004. So the entire sequence of denotification, purchase in auction, denotification, acquisition, etc. is all Malus before it was anything to do with me at all, with my family also. Much later in 2004, this fellow's brother-in-law buys it from sale deed. Then 2005, conversion is done. Gift deed comes to my wife in 2010, his sister. And then in 2014, an application is filed to allot an alternative area because no compensation, because the admittedly that whole thing has been used or otherwise encroached upon, etc., or dealt with. So they say, look, this whole thing will to reverse the whole thing and to give pristine land again. Therefore, alternative is asked. It is done for a large number of people, and then 2020 and 2022, the sale deed. This is the broad picture. Today, you are having in 24 some kind of a outburst as if some massive scam has happened, which is not open to anything. This is just a perspective. I repeat, with great respect and humility, and this is important, I should have said so in the beginning. And I'll be making it as the first point in my rejoinder when I file it. I am always dealing with these facts on and off because I don't want my Lord's brothers to feel in conscience that I'm suppressing or avoiding anything. But I'm very clear that these two counters we have received yesterday in day, full of facts, as if your Lordship is hearing a criminal trial. Now, my respectful and humble submission is that I am not required to answer a single fact. Don't misunderstand me. When I give your Lordship these dates, they are landmark dates. I am A, not required to, B, I am not obliged to, C, I am not going to reply to these facts. Why? Because the issue is the sanction.
ಈ ಖುಷಿ ಇರ್ತಲ್ಲ ನಾ ಸೋತ ನಾನು
yes.
Now, I am not required to do that because the validity or otherwise of the sanction depends on the argument of the applicant, the argument of, if I may call myself as the non-applicant or the objector, and the governor. There is no list in a counter affidavit in the High Court that your Lordship will give a civil or a criminal decree on these facts. Your Lordship will pass a criminal law order. Your Lordship will find a guilty. Your Lordship will give a civil decree. This is not the job. Question is what you are today, this is important, Malas, what you are today arguing in these two objections full of facts is not what the governor did. Is not what the governor did. The governor passed a simple 4-page order. Today, you are not a super governor to justify that governor's order by giving all these facts.
No, it is on the basis of their requisition sanction is granted. So
Correct.
they are defending.
No, of course they will defend. I understand. But I'm just saying my necessity to rebut individual facts, to say that, look, this is criminal, this is not criminal, this is culpable, this is not culpable, doesn't arise. Because your Lordship has no reasoned order. Yes. Suppose one of the governor had passed a reasoned order. Lordship has dealt with many cases like this. Sanction is not a new thing. Governors pass reasoned orders. Then possibly I'd have to say, look, this is where the governor has said 2 + 2 is equal to 5. And he's wrong. Because on that date, did not exist or something I could say. But there is no need for that because there is nothing to, I'm not here to answer a list on a civil or a criminal side with the private people, complainants. That's the perspective I'm urging my lords to keep in mind. So whatever I say, I say it really more from the purpose of disabusing and creating the fact that your Lordship is, I'm not keeping away anything, but not because I'm obliged to or required to in this proceeding to answer anything. The facts, otherwise, just to end on the facts, show the overriding point that public servant whom you are seeking to prosecute. Has your lordship ever seen a public servant? And now, of course, we have repealed that section also in the PC Act, where Malus, for this long period when this person was born, Malus, this brother-in-law, in which year? Which year the brother-in-law by? 2004 till now. I have never dealt with the file. I'm not the portfolio minister. I have never passed any order, and the decisions taken of denotification otherwise have been passed for a number of people, not for me alone. And yet after 20 years, Malus, 24 is 20 years after 2004, this is happening. So that has to be kept in perspective.
He also says this, that he is not in any manner that the commission of discharge of official duty. He says so.
No. Now, Malus, the other aspect is, Malus, this 218, your lordship's old 197.
Yes.
Broadly. Now, Malus, my short point, this is more or less what I said earlier, because nothing major has come for me to deal with in the counter. But Malus, broadly, the points are threefold, if I may ABC tell your lordships. Malus, the granting is under 218 also at page 47. Your lordship noticed that last time,
Yes.
page 47 specifically. Now, Malus, this section has to have some specification of the ingredients of the offense. What offense, how offense, which way the ingredient of that section is fulfilled.
That's
before you
quasi
get-
sanction.
That's right. So, Malus, I'm just saying that specification is nowhere there. I am not concerned. I'm not saying that you had to grant. You didn't have to grant. It's possible to say, I don't have to grant now, I'll grant later. That's not what he's saying. He has granted. My question to myself is, he has granted on what? Well, the ingredient, I say 420. So you have to say that I am granting for 420 because in this way I came to him, I represented to him or misrepresented, I got movement of property, etc., something. There is nothing. It's established that 218, etc., must make out the attempt to make out at least the ingredients of the offense. That is missing. That's separate, Malus, and independently as fatal as the submissions I have made, Malus, regarding 17A.
Yes.
Now, Malus, I'll just end in a minute. Give me. Well, may I say that since I've argued most of the matter, let me just note the paras. It's a
Of-
more intellectual.
judgment?
No, so I've done with the matter, Malus, as far. I'm just, Malus, since it's more of an intellectual thing, I'm not arguing it. But Malus, this submission that he's not bound at all may be a larger legal issue. which
Not
your
bound
lordship
of
may-
what?
By the cabinet.
That way.
That let me oralize it for
So
lordship.
that's a
I'm
prima
not,
facie, we will see.
Yeah,
Well,
yeah.
Yes.
but well, only why I'm saying it, I'll tell you. Well, there is a judgment of MP establishment which suggests otherwise. As simple as that. My learned friends rely on that. Now, whereas Nabam Rabia, which is a constitution bench,
Para 156.
is the conclusion.
Yes.
But it cites, well, as the conclusion says you can only act in your own discretion in 3 cases. It lists them. I read you last time, 156. 155? 155.
155. right,
Now,
yes.
admittedly,
Uh.
this doesn't fall on those 3 on the text. Clearly. Now, MP is also 5 judges. Nabam is also 5 judges.
Yes.
Nabam is later.
Later.
But Nabam, with the conclusion in 155, saying only these 3 categories in which we don't fall, cites fellows MP in 7, 8 paras, just note the paras, because it's a very long judgment,
Yes.
140 to 142,
Yes.
you don't say what these paras are, you stop in between the sentence. I'm sorry, but just cut out that para. It is cited in the following paras, Manoj. 116, 118, 128-29, 315, 317, 2 more paragraphs, 326 and 337, and lastly 362. Now, a later judgment citing the earlier one, And well, coming clearly to a conclusion in 155, which categorizes three things where we don't follow. At least the High Court Balas should prefer to follow the later one, but that at the moment I don't argue. I'm just pointing out that not that Balas, it's a frivolous argument. I'm not that Balas.
The 5 judges saying of this court.
Yes, yes.
So due to-
And well, your lordships have, of course, this is obvious, Balas, I don't need to, a 5-judge full bench of your lordships, Karnataka High Court, said that when there is some apparent variance between an earlier 5 judges and a later 5
So
judges,
later will prevail.
and you will follow that. That's your lordship citation of 1979.
No, that's,
SCC online. Many of them are there. Whereas I would therefore say that, of course, reserving fully my right to not only file, but to argue a rejoinder fully. This case is a fit one, whereas this sanction cannot be there.
Yeah.
What they do in future, what they find, what is applied, etc. This sanction must go. This sanction actually can and should go on the admission of some of the complainants themselves. But whereas that apart, I'm not dependent on their admission. Your lordship is entitled to say on both counts. It's not that your lordship can say because of those reasons it doesn't stand, but I otherwise go into it, otherwise also find this. This sanction is, well, it must go for the separate reason that there is no reason. None at all. Those balas are my submission, very deeply obliged. I reserve all those rights
All right,
because
yes.
I'm sure some, in the light of my arguments, your lordship rarely has that I finish my argument. Then a new
No, no,
counter
you
will
can-
come,
you
and a
can
new
apply-
angle will come, and that new angle I can't do this, therefore
No,
the
that's
lordship
all
got there
right.
in mind.
Yes, anyone today or
Well, I am ready, my lord, but if the Solicitor General, my lords, it would be appropriate if lords
is,
here.
is there?
I have a
Yeah,
suggestion.
my lord, I'm here, my lord. Am I
I have a
audible?
suggestion which on one of the
One-
rare occasions, Mr. Mehta may agree with, may agree, I don't know, Manas. It may be a rare day, but he may agree. Well, Saturday, I'm told is a working Saturday for
Yes. It is.
This Saturday.
mutual benefit.
Yes,
yes,
this
yes,
Saturday
this
is.
Perhaps you
Saturday.
do not know, Mr. Mehta, so your agreement will be in our mutual benefit.
No, I don't go by the benefits, Dr. Singhvi, but Saturday is fine
Yeah.
with,
Saturday is fine.
Saturday is fine.
subject to Mr. Maninder Singh is also appearing, my lord, my learned friend.
Where is?
Somebody can start. Manas, let it
Yes,
go on.
yes.
I may be
Finish.
permitted to start. Please.
It won't finish anyway, so then.
No, Mr. Singh, would
fine.
it be possible?
Saturday is fine. No
Yes,
difference.
yes, Solicitor General's convenience is important.
Can't hear.
Well, that is 20.
First.
Now, whoever wants to submit, then you will have to resubmit on when the rejoinder is filed if needed.
Please, correct.
But what if you want to submit, you can submit.
Yes, please.
31st. We are talking of this Saturday, 31st.
Yes, this
31st, yes, my lord.
Who are you? Intervener? Intervening as what? Petition? For what? Your fundamental right, who has taken away? So first, what is your right that is taken away? Hmm.
Just can I interrupt for 30
No, no,
seconds?
this is
There's
not.
an old saying, Malas, sometimes, Malas, your friend can be your worst enemy. Please don't think that I have set up anybody, Malas. I'm not
No, no,
interested.
no, I-
The problem is, Malas, anybody comes and argues, people blame me.
No, I don't think
No, well, that
I don't think
happens.
you need a friend to be set up.
No, Malas, a friend is worse than an enemy sometimes. That has happened many times in litigation.
Where does this road lead to? The caterpillar would say, you don't know where you want to go, it would be taken there.
We'll see, we'll hear. Not in this, it is, no, not,
Lord, if lordships are to start hearing us from Saturday,
wait, sir,
no.
damage will be caused to the state.
No, I would assist the
That-
court on behalf of
No,
the
no, sir.
governor. Thereafter, Mr. Maninder Singh is there.
We are not hearing a PIL here. It's an order of the governor that is called in question by the person against whom the order is passed.
On par with the petitioner, the response, it constitutes significant.
All right, we'll see. Wait. No, your application is, you have filed it. We'll consider it. Yes.
If Saturday, my lords, if the Solicitor General wants to start,
Huh.
it would be appropriate, my lord, that he
Yes,
finishes
sir.
it and thereafter I continue.
Yes,
Is
but
there?
if
So
he
Mr.
has something-
Maninder Singh is
He'll
also
argue.
there.
We are ready.
Let it be
Whoever-
10:30. I will complete and Mr. Singh can start.
Yes,
Please.
Today,
No, my lord, Saturday, my lord, if you allow.
Saturday, all right.
deeply obliged, deeply obliged.
10:30, my lord, can it be at 10:30?
We'll start it with 10:30 and conclude it. Yes.
Please.
And all of your, the rejoinder later on.
Well, Legion will have to be later because they will be having a lot of things, but
I
one
know.
day more I'll finish it off. One day more.
That's all right. Yes.
So
I'll
Saturday,
take account of everything and make my note also accordingly.
Yes. Yes. Let
As
the
single
respondents,
note, yes.
respondents finish.
Yes, yes.
Hope all of you will finish on Saturday.
as much as possible, we'll finish Saturday.
All right.
Once we allocate time for us, so that we know how much time we have.
It's all right.
Each of you.
No, no, it's all right, my lord.
Each
We'll,
of us will not allocate.
All right. I don't think each of you are saying something contrary to each other.
No, no.
Then-
Absolutely not.
All right.
But two broad issues, my lord, we will address that, subject to what there are and Solicitor.
No, then Solicitor General will start
We'll
first.
start.
And all of you will
We'll follow.
next follow. Yes. Then we'll do it on Saturday.
Yes.
Yes. Heard. That I will do. That we will do.
Grateful to you, lord.
Heard the learned senior counsel Abhishek Manu Singhvi, who has completed his submissions for the present and would reserve his right of rejoinder submissions. Once the submissions are concluded by the respondents, the learned Solicitor General submits that
Saturday.
the matter would be taken up on 31st. He would complete his submissions on the said date. Records may be required, sir.
I will keep, my lord, my record present.
Yes,
which
sir.
can be-
Would complete his submissions on Saturday. List the matter on Saturday at 10:30 a.m. Interim order granted on 19/8/2024 shall continue till the next date of hearing. Yes. ನಿಮ್ದು ನೋಡೋಣ ಆಮೇಲೆ. Wait, yes.
One of the record, including the other application, status of the other applications also, your lord.
What applications?
You have produced 4 other complaints which are pending.
No, every record will be produced.
Not only passing of this order, my lord.
Oh, you mean from the office of the governor?
Yes, yes. They had said,
4
brothers,
applications also. What
I
is
have
the
named them.
status
I have
of
named those applications.
No, but I'm unable to see who
That
is
is-
requesting.
That is for the perusal of the court. They will do it.
The
Yes.
perusal of the court, my lord.
No, it's my contention, so Lordship can peruse it, of
Kindly
course.
peruse.
My
But it
contention
is a
is writing.
state has nothing to do with this, my lord.
Governor
Accused,
has everything to do with.
potential accused and the governor
is the one who
will.
has passed the order, sir.
The complaint that have been referred to by my learned by the Singhvi are under 19. They are not under 17.
No, I asked the senior counsel that they are all after investigation
Exactly.
and wanting